5 seconds to go. Start. Section 266 states that transport vehicle means a public service vehicle, a goods carriage, an educational institution bus, or a private service vehicle. Section 66 stipulates necessity for permits. Subsection 1 thereof provides that no owner of a motor vehicle shall use or permit the use of the vehicle as a transport vehicle in any public place, whether or not such vehicle is actually carrying any passengers or goods, save in accordance with the conditions of a permit granted or countersigned by a regional or state transport authority or any prescribed authority. Various provisos have been appended to the main provision stipulating conditions for use of the vehicle and purpose of carriage of goods vehicle. Subsection 2 states that the holder of a goods carriage permit may use the vehicle for the drawing of any trailer or semi trailer not owned by him, subject to such conditions as may be prescribed. It is necessary to mention here that a proviso has been added by Act 54 of 1994 with effect from 14th November 1994, allowing the holder of a permit of any articulated vehicle to use the prime mover of that articulated vehicle for any other semi trailer. Section 2.2 defines articulated vehicle to mean a motor vehicle to which a semi trailer is attached. In the case at hand, the findings would show that the appellant number 2 did not have a permit for the vehicle. There is no dispute that the vehicle initially had a temporary registration and eventually the permanent registration. It is the stand of the appellants that the tribunal and the High Court did not appreciate that the chassis of the vehicle was sent to the body where the body of the truck was fabricated, and when the vehicle was driven out of the workshop, at which point of time it met with an accident. A contention has been made that the insurance policy was in force at the relevant time and hence the insurer is legally obliged to indemnify the insured. An distinction has to be made between route permit and permit in the context of section 149 of the Act. Section 149(2) provides the grounds that can be taken as defense by the insurer. It enables the insurer to defend on the ground of breach of a specific condition. The vehicle may not be permitted to ply for hire or reward for organized racing and speed testing or for a purpose not allowed by the permit under which the vehicle is used, where the vehicle is a transport vehicle or without sidecar being attached, where the vehicle is a motorcycle. That apart, it also entitles the insurer to raise the issue pertaining to a condition that excludes driving by a named person or persons or by any person who is not only licensed or by any person who has been disqualified for holding or obtaining a driving license during the period of disqualification or that excludes liability for injury caused or contributed to by conditions of war, civil war, riot, or civil commotion. A further defense that can be availed of by the insurer is that the policy is void on the ground that it has been obtained by non-disclosure of the material fact or by representation of act which is false in the material particular. On a perusal of the written statement filed by the owner and the driver, it is evident that the factum of accident having been caused by the vehicle in question had been denied. That apart, there is also a denial of liability that relates to the manner in which the accident had occurred as alleged in the claim petition. It was the specific assertion of the insurer before the tribunal that the vehicle was running in contravention of the provisions of the Act, for it did not possess a route permit. The tribunal, on the basis of the materials brought on the court to the effect that the route permit was issued on 27th February 2013 and the accident occurred on 19th February 2013, returned a finding that the vehicle in question did not have the permit. As stated earlier, the High Court has affirmed the same. Learned counsel for the appellants would submit that in the obtaining factual matrix, appellants would submit that in the obtaining factual matrix, the breach would not exonerate the insurer from satisfying the judgment and an award in terms of section 149 of the Act. He has drawn inspiration from the decision of a three-judge bench in National Insurance Company Limited versus Sharma Singh and others. In the said case, the court was dealing with the interpretation of section 149(2) vis-a-vis the proviso appended to subsections 4 and 5 of section 149 of the Act. The issue centrally pertained to the necessity of having a driving license. After adverting to various provisions, the court also delved into the fundamental concept of third party right. Stop.